talking to you today about the topic of unlawful discrimination. And basically, the reason why I've chosen this topic is that it seemed to me that there have been 2 or 3 recent cases that would form an interesting structure to a talk about the burden of proof and inferencing in discrimination cases. And that's why I've taken that as the topic for my talk today. Because, of course, the burden of proof and the inferences that a tribunal may make are central in determining discrimination claims. And I know I don't have to say to employment lawyers here, but I think there may be 1 or 2 people who are perhaps not employment law practitioners, so that we all know, or should know, that the claimant must prove facts from which the tribunal could find that the acts complained of were because of the protected characteristic, in the absence of an adequate non-discriminatory explanation from the respondent. That is what is known as the prima facie case. From the primary facts, the tribunal is looking to see what inferences or secondary facts can be drawn. And in the absence of an adequate non-discriminatory explanation, the burden of proof would then shift to the respondent to show that the treatment was in no sense whatsoever on the prohibited ground. So bluntly, in discrimination litigation, the claimant's lawyers are looking for evidence to support that prima facie case. And of course, the respondent's lawyers are looking for rebuttal evidence in respect of that evidence that may be in the case, and to deploy a non-discriminatory explanation. And as somebody said in a case somewhere, it's simple, isn't it? Well, I think it probably is, but I think if one looks at the history of the cases, one can see that from time to time we thought that the cases were settled back when we had Barton guidelines, which some may have thought were a bit like tramlines, and then the Igen and Wong guidance and Madarassy and so on. We maybe thought that it had all been done. So although we've had the Burden of Proof Directive since 1997, which was then transposed into UK legislation in or about the late 90s, we still have a lot of case law coming through. It bubbles up from time to time. And some of the cases are of interest, and so I've taken, as I say, 2 or 3 cases from the period of 2020 and onwards, just to examine where we are with the burden of proof. So, again, just to reiterate, we had a key case in the Court of Appeal, which was the Madarassy case, which established that there is a 2-stage analysis, and the burden of proof provision does not expressly or impliedly prevent the employment tribunal at the first stage from hearing or accepting or drawing inferences from the evidence adduced by the respondent disputing and rebutting or attempting to rebut the claimant's evidence. Madarassy, of course, established that something more is required, not just the fact that the person bringing the acts complained of has the prohibited characteristic and these things, they say, happened, but there is something more is required. So there is the something else issue, and the fact that the respondent's behaviour calls for an explanation does not mean that the claimant automatically gets through. There still has to be a reason to believe that the explanation is on no grounds whatsoever attributable to the protected characteristic. So moving then to the next matter. This is the first recent case that I wanted to discuss, because I think this one and the Field and Pye case, which came out at the end of last year, in some ways show two different approaches or analyses. And I think it's quite illustrative to look at those. So the Otshudi case was a Court of Appeal judgment of Lord Justice Underhill. Lord Justice Underhill is invariably clear in his analysis, in my view, and very authoritative. So it's always instructive, I find, to pay careful attention to his judgments. So this was a case where a woman of short service who was a photographer working for a clothing retailer was dismissed after 4 months' service, ostensibly, it was said, for redundancy. She was from the Democratic Republic of the Congo. She was called one day into the managing director's office, and it was the managing director himself who dismissed her summarily for redundancy. The redundancy reason was a lie. There was no redundancy, and she suspected that she was the victim of unlawful discrimination. And she made that accusation. And she raised a grievance alleging discrimination, as is so often the case. And the respondent just ignored it, didn't do anything about it, and it remained unanswered. She then went on to issue the proceedings, obviously. That's why we've got the line of cases that we're discussing today. And shortly before the case came up in the Employment Tribunal, about 3 weeks beforehand, the respondent changed its position in respect of the reason for the dismissal and amended its ET3 to assert that it was actually false that they'd dismissed her for redundancy, and that they'd used that reason because there was a belief that some stock had gone missing and that she was the thief. So there was a flimsy evidential basis for that allegation. It wouldn't have been a reasonable belief by any stretch, but that is what the employer argued in the Employment Tribunal. The claimant alleged racial harassment, which seemed a bit of an odd cause of action in the circumstances, but that's what she was claiming. And that engaged the burden of proof, section 136 of the Equality Act. And the Employment Tribunal did not specifically refer to the burden of proof within section 136, didn't refer to section 136, nor did it overtly refer to the stage 1, stage 2 analysis. And the tribunal found that the evidence that the claimant had been attempting to steal clothing from her former employer was flimsy. It was something that they would not accept. And the managing director was alleging that he was relying upon the redundancy reason to mask the belief that she had been stealing clothing. And so the tribunal found that that reliance on a false reason was something to be added into the pot in terms of the burden of proof. Because the managing director knew it was flimsy and they knew that they couldn't prove it. So they went on to say that they could infer that the managing director was in fact trying to cover up the real reason, the tainted reason, which was to do with her ethnicity, the fact that she was a black African woman. And so in reaching the conclusion, they took into account the managing director's strong reaction to her allegation that he was being racist in dismissing her, that race was the true reason, and he reacted very badly to that allegation. So they took that into account as well. And they also took into account the failure to deal with the grievance. Now, dealing or not dealing with grievances is something that comes up time and time and time again in discrimination cases. And I go on to discuss some of that later in the paper that I have put in the handout. The the EAT dismissed the respondent's appeal, as did the Court of Appeal. And it's the Court of Appeal judgment that obviously I'm selecting to discuss today, because Lord Justice Underhill commented that although the tribunal had not explicitly referred to Section 136 of the Equality Act, the burden of proof provision, it was reasonably clear that they'd had that provision in mind in reaching their decision. And they had been seeking to follow the two-stage process. And the Employment Tribunal's reasons for finding a prima facie case had been established, and they took into account that he was being intimidatory and refused to deal with the grievance as I've already outlined. And they also took into account the persistence of the reliance until a late stage upon the false reason for the dismissal. Even though the reliance on the false reason was ostensibly on their case to minimise confrontation, when in fact they were still relying on it a long time after that possibility of confrontation had passed by. Having rejected the explanation, they found that the respondent had not proven its case, and that meant that the act complained of was established. Moving on to the second case, which is Field and Steve Pye. This was His Honour Judge James Taylor, and he pulled back, as it were, the analysis to including the fact that it was an error of law in this particular case for the tribunal not to demonstrate that they had adopted a two-stage approach. And this was a Section 15 disability case. And this one is covered in my handout at pages, I think, 3 to 5. So this case, I think, is just sort of in distinction to the Otshudi case. And so Judge Taylor found that there was sufficient evidence for the tribunal to look at and for the claimant to establish that there had been a prima facie case proven by her, because the tribunal had actually failed to grapple with that evidence. It somehow just sort of glossed over it. And it was that failure which meant that the Employment Appeal Tribunal could find that for the claimant and allow the appeal. Because although the inferences to be drawn are from the primary facts is a question of fact, not law, where the tribunal in effect ignore or don't grapple with or don't take into account in some way or explain their treatment of the evidence, then that in the learned judge's judgment is that is an error of law. So I've set that out in more detail at pages 3 to 5 of the handout. And now I just want to move to some practical issues. This is really sort of emphasising that what is in play are facts. It's essentially, the burden of proof is essentially a fact-finding exercise. And so the sorts of facts that might come into play in establishing a prima facie case, or on the other hand, the fact that it's not anything to do with the protected characteristic. The sorts of things that come up from time to time are things like statistics. Because the organisation has, usually it's a more sophisticated organisation such as a public sector body, will from time to time have taken the trouble to analyse the sex and race makeup of its workforce. And the claimant may say, look, I was treated like this, I wasn't promoted, for example. And if you look at the statistics, you can see there are X number of people with my protected characteristic, these grades, and very few of us seem to be promoted into the next grade. Stats of that sort. Now, it's really quite important when you're looking at statistics to remember that what is being looked at are essentially facts, and these can change. So you would need to make sure that you're analysing the stats for the relevant period and for the relevant place. So, for example, you might have a local authority saying, well, here's the stats for the local authority, but it doesn't really give you sufficient analysis within the particular employing department, such as the education department, by way of example. So you would need to look at the stats to see what they do show. And in terms of underrepresentation of employees, there are obviously, you've got to look at comparators. Are they truly comparative within that statistical analysis, and so forth. And then if we move to matters such as an ACAS questionnaire, which very, very, very rarely are used, but can be useful, then a tribunal will be interested to know whether or not pertinent questions have been asked in the questionnaire, which have been evaded or not answered satisfactorily for some particular reason. So that's a tool, particularly perhaps for a claimant to consider when preparing for the litigation. But of course, all of these things have to be appropriate to the case in hand. Everything in a discrimination case will be fact-specific, so it's really important when you're looking at the evidence to make sure that it is appropriate to the case, and so on and so forth. Preparing witnesses, in terms of a particular case I was in, the witness who was alleged to have discriminated against the claimant by not appointing them to a particular post said, I can't appoint white women then. Something that was picked upon by the barrister for the claimant to say, this is terrible, this is facetious, this shows the mindset, look at this is so on and so forth. The tribunal itself was fairly forgiving and said, the way that the question had been put was such that it elicited that reaction. But of course, you don't want your witnesses to be at the mercy of a tribunal in coming to a finding favourable to your client. So it's important, obviously, we do this day in, day out, to ensure that the witnesses know that they're to answer questions, they're not to ask a question, and so it's not appropriate for them to sort of pose rhetorical questions like, well, what was I supposed to do? Matters of that sort. Dealing with grievances, it's important to remember that just because the respondent has been woeful in some regard with the handling of a grievance, that does not necessarily make them guilty of the discrimination alleged. It again comes down to the facts. It's not a pretty fact, is it, if the employer has gone, don't want to touch it. They may consider doing something like getting somebody from outside the organisation to deal with the grievance, for example, if they're worried about those sorts of things. But this is because the respondent doesn't have to show that they acted reasonably or fairly to avoid a discriminatory finding. So they've got that little bit of leeway, but understandably, if it's your client, you'll want them to deal with grievances in an appropriate way to the circumstances. Parking it and forgetting about it can lead to allegations of perhaps victimisation because you would have dealt with it had it been someone else not involved in the litigation. So I just then wanted to pick up to sort of segue into something, and it is in respect of the burden of proof in indirect discrimination or reasonable adjustments claims. And in that case, the burden of proof doesn't apply. That's those aspects, the PCP and whether or not there was a reasonable adjustments. Those are factual matters which are not subject to the burden of proof two-stage test. So I just thought that I would tie that in.